Welcome to State Law Exposed, where real people, real laws, and real money collide. Every story you're about to hear happened right here in Florida, under real statutes, in real courtrooms, with real consequences. These are the laws that Airbnb is hoping you never have to Google. If you've ever rented your property on a platform and assumed the platform had your back, you're exactly where you need to be. Hit subscribe right now, because the next story might be your property. This is State Law Exposed. Angela was a licensed Airbnb host in Miami Beach. 2 years, 0 complaints, 0 violations, every permit filed, every tax paid. She accepted a booking from a guest who listed 2 people. A code enforcement officer knocked on her door on the 3rd night of the stay. He counted 6 people inside. The fine was assessed against Angela, not the guest who lied, against Angela. She called Airbnb. Airbnb was sympathetic. Airbnb removed the guest from the platform. Airbnb did not pay the fine, because in Florida, the ordinance does not fine the platform. It fines the property owner, every time, regardless of what the guest told you. Here is what Florida law actually says about short-term rental enforcement. Angela had been hosting on Airbnb for 2 years from a bungalow in one of Miami Beach's approved short-term rental zones. Miami Beach restricts STRs to specific commercial and hotel district zones, and Angela was in one of them, having done every step of the compliance process correctly. She had her DVPR vacation rental license, required under Florida Chapter 509 for any property rented more than 3 times per year for periods under 30 days. She had her Miami Beach business tax receipt, her resort tax registration certificate. She was remitting tourist development tax and state sales tax on every booking. She was, by any standard, a model host. Then a guest named Marco booked her 2-bedroom bungalow for 3 nights and declared 2 guests. Angela had no reason to doubt it. Her listing stated the maximum occupancy. Her pre-arrival message confirmed it. Marco acknowledged it. She approved the booking. On the 3rd night of Marco's stay, a Miami Beach code compliance officer responded to a neighbor's noise complaint. He knocked on the bungalow door. 6 adults were inside, not 2, not 4. 6, exceeding the Miami Beach occupancy standard of 2 guests per bedroom, which for a 2-bedroom unit means a maximum of 4. The officer documented the violation, photographed the unit, and issued a code enforcement notice to Angela as the property owner. The violation, exceeding maximum permitted occupancy for a licensed short-term rental. Angela called Airbnb support that night. The representative was empathetic. Airbnb noted that Marco had violated their terms of service by misrepresenting the number of guests. They removed Marco from the platform. They did not offer to pay the fine, appear at the hearing, or indemnify Angela for anything. The fine was hers to deal with. Before getting to what Angela did next, you need to understand the regulatory system she was operating inside, because Florida's short-term rental framework has 3 distinct levels, and most hosts only know one of them. Level 1, state licensing. Under Chapter 509 of the Florida Statutes, vacation rentals operating more than 3 times per year for stays under 30 days must have a DVPR license. Angela had hers. Level 2, state preemption. Florida Statute SS 509.0327 prevents municipalities from banning short-term rentals or regulating their duration and frequency, but only for ordinances enacted after June 1, 2011. Any local ordinance on the books before that date is grandfathered and stays fully enforceable. Miami Beach's STR restrictions predate that cutoff. They are grandfathered. They are the law. Level 3, local operational regulation. Even POST-2011, municipalities can regulate occupancy, noise, parking, safety, and registration. Miami Beach uses this authority very aggressively. Here is the part the source document got wrong. And it matters. Florida Statute SCO 162.092 gives municipalities with populations of 50,000 or more the authority to adopt enhanced code enforcement fine schedules, passed by majority +1 vote. Under this enhanced authority, a first violation may be assessed at up to $1,000 per day per violation. A repeat violation can reach up to $5,000 per day. These are the state-imposed ceilings, and Florida courts have enforced them hard. Miami Beach tried to impose its own STR fines, starting at $20,000 and escalating to $100,000. A Florida Circuit Court struck those down as illegal. The 3rd District Court of Appeal affirmed. The caps at S. 162.09 are not suggestions. They are the law. For Angela, a licensed host with a 2-year clean record receiving her first ever violation, the maximum daily fine was $1,000. Assessed for 1 day, her fine, $1,000. Still not hers to pay, but far more contestable than $5,000. The fine notice gave Angela 30 days to pay or request a hearing before Miami Beach's Special Magistrate. Her neighbor, also a VRBO host, told her just to pay it and move on. Angela did not want to pay $1,000 for something a guest did. She called an attorney. The attorney's first question was not about the fine amount. It was, do you have Marco's booking confirmation listing 2 guests? And do you have your pre-arrival message where you confirmed the occupancy limit? Angela had everything. Screenshots of the Airbnb booking page. The exchange where she told Marco the 4-person maximum, and he confirmed understanding. The attorney said, good, 2 tracks. 1 to fight the fine down through the special magistrate. 1 to make Marco pay for what he caused. Angela's attorney built a good faith compliance defense. 2 years of DBPR renewals. Business tax receipt. Tourist development tax remittance records. A photograph of the in-unit occupancy posting. Required under Miami Beach STR rules. And compliant. The pre-arrival message exchange. A declaration that Angela had taken every reasonable precaution available to a licensed host. The argument was not that the violation hadn't occurred. 6 people were in the unit. The argument was that Angela's documentation of good faith compliance, combined with Miami Beach First Offense Mitigation Program, which allows the special magistrate to reduce fines for hosts with documented clean compliance histories, entitled her to a reduction. The special magistrate reviewed the evidence. 2 years clean, posting compliant, pre-arrival confirmation documented. The fine was reduced to $250. While the hearing was being scheduled, Angela's attorney sent Marco a demand letter. The legal theory was direct. Marco had made an affirmative misrepresentation in his Airbnb booking, declaring 2 guests when he intended to bring 6. Airbnb's terms of service, which Marco had agreed to when creating his account, required accurate disclosure of the number of occupants. That agreement constitutes a contract. Marco's false representation breached it. His breach was the proximate cause of Angela's fine and legal fees. The demand, $500. Marco was out of state. The prospect of returning to Miami Beach for a small claims court appearance, with documented booking records proving his misrepresentation, made settlement the rational choice. He paid $500. Angela's $250 fine was more than covered. Her net position, after fighting back, $0 out of pocket. She went back to hosting. She now screens every booking differently. The most important lesson in Angela's case is the one that surprises every Airbnb host when they first hear it. The platform does not share your regulatory liability. Airbnb's agreement with Angela was to facilitate the booking, to handle payment, to provide a platform, to give her tools for communicating with guests. It was not to defend her at a special magistrate hearing. It was not to indemnify her against municipal fines. It was not to appear in her city's code enforcement process as a co-responsible party. When the code officer knocks, the only name that matters is the one on the property record. Miami Beach doesn't fine Airbnb. It fines you. VRBO doesn't protect you either. Neither does any other platform. The platform is the marketplace. The liability is yours. This is not a gap in the law. It's a feature of how Florida's municipal code enforcement system was designed. In 2024, SB 280 passed the Florida legislature and would have significantly centralized vacation rental regulation under the DBPR, pulling more authority away from municipalities and creating a more uniform statewide framework. Governor DeSantis vetoed it in June 2024. The result, the framework that existed before SB 280 continues unchanged into 2025 and 2026. That means the patchwork survives. Miami Beach enforces its grandfather PRE-2011 ordinance. Orlando restricts whole home rentals. Key West has its own rules. Fort Lauderdale has its own rules. Clearwater Beach has its own rules. Every Florida STR host is operating under 2 layers of law simultaneously: the state licensing and preemption framework under Chapter 509, and whenever their specific municipality has adopted in operational regulations. You cannot assume your city works like any other city. You have to know your specific ordinance. Angela went back to hosting after the case closed. She added 3 practices she hadn't used before. First, an occupancy compliance clause in every pre-arrival message, requiring guests to confirm by name every person who will be present during the stay, not just the number listed at booking. Second, a smart Wi-Fi router that shows the number of connected devices, giving her a rough proxy for how many people are in the unit without entering or violating guest privacy. Third, she now asks her property manager to make a single exterior check on bookings with more than 2 guests listed. Not intrusive, just a drive-by. None of these practices guarantee compliance. Marco could have left his devices on and brought 6 people anyway, but they create a documented paper trail for due diligence, which is exactly what the special magistrate wanted to see. Documentation is not just compliance. In Florida, STR enforcement, documentation is your defense. Here's the minimum compliance package every Florida short-term rental host should have in place before their next booking. State GDPR vacation rental license, not optional, required by Chapter 509, local business tax receipt from your specific city, not the county, the city. Resort tax registration certificate if your city requires it. Tourist development tax registration with your county. In-unit posting of occupancy limits, post contact information, and emergency contacts required in many Florida municipalities and good practice everywhere. Pre-arrival message with written occupancy confirmation for every guest, screenshot everything. Annual check of your specific city's STR ordinances change, and what was compliant last year may not be this year. If you are operating in a city with APR E-2011 grandfathered ordinance, Miami Beach, parts of Miami, parts of Broward, assume the rules are stricter than the state minimum and verify directly with the city. If a Miami Beach or any Florida municipality code enforcement officer appears at your door while guests are present, stay calm, be cooperative, and do not obstruct the officer's documentation. Do not argue at the door. Do not try to negotiate the fine on the spot. Accept the notice. Read it carefully. Note the violation date, the specific violation cited, and critically, the deadline to request a hearing. In most Florida municipalities, this is 30 days. Missing that deadline means automatic fine assessment with no right to appeal. Call an attorney before that deadline, not after. Bring every piece of documentation you have to that attorney. Your license, your tax filings, your listing, your pre-arrival messages, your in-unit posting photo. The special magistrate process in Miami Beach is designed to allow good faith compliance evidence to reduce fines. But that evidence has to be assembled, organized, and presented correctly. The attorney is not optional. The deadline is not flexible. 2 things. Right now. First, find your city's specific STR ordinance, not the Florida State Framework, your city's ordinance, and read the occupancy section. Know the number. Post it inside your unit. Photograph the posting. Second, update your pre-arrival message template to require every guest to confirm by name who will be present. Screenshot every confirmation. Those 2 actions cost nothing. They take 30 minutes, and they are the difference in a special magistrate hearing between a full fine and a reduction. Because when a code officer knocks, and in Florida's STR enforcement environment, the question is when, not if. The only protection that matters is the documentation you assembled before they arrived, not the platform, not Airbnb support, not VRBO's terms. Your documentation, your license, your compliance record. That is what saves you. Now you know how to build it. 1 Airbnb host, 1 lying guest, 1 fine she didn't earn. Not because Angela was careless, she was licensed, registered, and fully compliant. But in Florida, when a code officer knocks, Airbnb does not answer. You do. That knowledge is power, and power should never be kept secret. If this episode made you want to update your house rules tonight, hit like right now. Share it with every Airbnb and VO host you know. You never know whose fine you might be preventing. And if you're not subscribed yet, what are you waiting for? New episodes every week. Real law, real stakes, real people. Until next time, stay informed, stay protected, and make sure your guests know who's the fine. This has been State Law Exposed.